This podcast is produced by The Brand is Female.
Always was, always will be. Aboriginal land. Always was, always will be.
Tanse, hello, and welcome back to the Matriarch Movement podcast. I'm your host, Shayla Oulette Stonechild, and I'm very excited and honored to have Caitlyn Kasper here with me today for another conversation, round two. She was on the show a couple weeks ago. And there I was asking a lot of questions about what's currently happening in Canada between Indigenous people and the findings of the unmarked graves, the mass graves, and taking Canada to international courts. Through this conversation, I learned so much, but I also realized that I still have so many questions for Caitlyn. And so we talk about Section 35. We talk about our rights as Indigenous people. We also talk about how to stay safe when dealing with police. We talk about defunding the police. Without further ado, Caitlyn Kasper. Hi. I'm very excited for this conversation. I have Caitlyn Kasper here with me today for a round two series because we're so involved with the conversation last time that I just knew I had so many questions left to ask, as well as all of you. And so thank you, hi to Caitlyn for joining us for the second time.
Thank you for having me back.
How have you been? It's been a couple weeks, I think, since we last chatted.
Well, actually, I have been working on a very interesting case that is relevant, I think, to a lot of the questions and interested areas of subject for your viewers with respect to duty to consult and Section 35 rights, Aboriginal and treaty rights. So I am primed and ready to answer any and all questions.
Yeah, I have my followers are very informed. Even in some of the questions they sent in, I was like, I don't even know that answer. So I'm also interested in coming along this journey to learn from you as well today. I think you touched on a point already, is what is the difference between duty to consult and relationship building?
So it's actually very interesting because in our history as Indigenous people, since contact with the Crown, there has been a large portion of that history where our concerns have been ignored, where our claims to what is in our treaty relationships in terms of what our inherent rights are as being a First Nations people with all of our own types of government systems, our own types of law, was overwhelmingly ignored by the Crown. And so part of the work that Indigenous people have done, and that the generations before us and what we continue to do now, is a lot of the grassroots activism that has meant to assert our rights and to make sure that they're being recognized in law. And in 1982, Section 35 of the Constitution Act affirms all existing title and Aboriginal rights. So they're now constitutional rights in Canada. So we have part of that is that when the Crown is setting off on any type of venture where infringement of those rights or potential infringement of those rights, so it can be either land title or rights to harvesting, fishing, economic activities, that kind of thing. There is a requirement for the government to engage on a process of consulting with the First Nation whose rights it will infringe. And so this duty to consult, interesting enough, is only the government, either the provincial or the federal government, can undergo this duty to consult. It can't be given to a third party, like a private interest, like a mining company or a land developer. You can't pass off the duty to consult, and that is kind of part and parcel with this idea of honor of the crown, whereby it was the crown who initially undertook negotiations, conversations with Indigenous people, and so therefore that relationship needs to continue through to this day. And so that, and there is, I think, a lot to talk about in that framework of duty to consult, and definitely differing opinions as to what the intent and purpose of it, as described by the Supreme Court of Canada, what the intent and purpose of it was supposed to be, and what it actually looks like today, I think are two very different things, and certainly are implemented differently across Canada. But it is very different than relationship building, which is positive action on behalf of the government to try and work with Indigenous nations in many different areas, healthcare, education, settlement of land claims and Indigenous rights issues. And it's supposed to be, positivist action that's undertaken to keep dialogue flowing, to keep a good relationship ongoing between Indigenous people and the Crown, so that we don't get to the point of severe breakdown, where we've seen the consequences of severe breakdown when there is a serious lack of reconciliation, a lack of negotiation, conversation. We have things like the Oka crisis that happen, Ipperwash, certainly the Wet'suwet'en, like out in British Columbia, and it is detrimental to ongoing relationships for those types of events to occur. So that is part of that. If we do the work up front, then resolving issues down the line later on becomes easier, or at least that's the thought.
Right. Well, and I think like for some Indigenous people, we're unsure of what our rights really are because of the continued denial of them within law and within the federal institution. And so can you touch a little bit on, your rights as an Indigenous person? Does that differ if you are Métis, if you're status, non-status? How does someone get to know a little bit more of the rights that they have as an Indigenous person?
So when we talk about Canada and the colonial state, we have rights underneath what they have said gives us rights, right? So this idea of Section 35 and affirming land title and Aboriginal rights. And then we have what we know to be our inherent rights according to our systems of law. And so trying to reconcile these two is actually a really interesting point of intersection right now in law, where a lot of the rights that have come from in Canadian law have come from the Supreme Court of Canada. And there is a lot of really great legal cases that many of you have probably heard about, starting with Calder, and then moving all the way through until today. And I think part of that, as in terms of why this all started with Calder, and I believe that was a case in the very early 1970s, 71 or 72, by the time it reached the Supreme Court of Canada. You have to also understand that we came from the Indian Act, where a provision of the Indian Act set out very clearly that it was against the law for Indigenous people to retain legal counsel, to pay a lawyer to represent them in court. All of that advocacy for Indigenous rights issues was simply not allowed prior to 1951, when the Indian Act was changed and that provision was taken out. So within the course, of 2 decades, all of a sudden we had the Calder decision coming right up to the Supreme Court. And this set off on a path of increasing framing of what our rights are and what they look like, how they're determined, and where we're getting to right now is this beautiful point in law where Indigenous law and how our customs and traditions describe our rights, describe our relationship with the land, is finally, for the first time, being listened to and acknowledged and taken as factual evidence in the non-Indigenous court settings. And that is a huge change from where we were. And I think, it's actually really interesting because in the Coastal GasLink decision, which was the injunction decision that Shayla, you have most likely heard about, where the RCMP was ordered to go in and remove individuals from the Unistoten camp and to arrest them. Justice Church was the name of the British Columbia Supreme Court judge who issued that decision. And this idea that she wrote about Indigenous law is not it was a reality or something that can be actually factually relied upon until it's adopted somehow within common law tradition is actually, when you take a look at the Supreme Court jurisprudence, that's not in fact correct at all. So, it would have been really interesting to have seen that injunction decision argued at the Court of Appeal and then, the Supreme Court of Canada, because I am sure that there would have been some choice words for the court to say about how that was interpreted, because certainly Indigenous law should not be regarded that way. In terms of how it interacts with non-Indigenous law.
Well, that brings me to my next question is, how can a legal colonial mindset prevent us from building relationships and education? This is from one of my followers.
So when the legal system approaches Indigenous rights, governance, laws, as being something that needs to be accommodated or something that needs to be tolerated or something that needs to somehow be subsumed into the colonial legal environment, where it's still this type of just total erasure of who Indigenous people are. And, if we can just chip away at who they fundamentally are as sovereign nations bit by bit, and then consume it, within our own systems, then I think that is the type of mindset that leads to a serious lack of trust within Indigenous communities, because you're not approaching it from this frame of mind where you have a system and I have a system, and we both made commitment to live here in parallel, but never to threaten each other's way of being. And certainly that, certainly the non-Indigenous colonial system has not followed up on their end of that commitment. And that, I think, has led many Indigenous communities to be very wary of continuing on that path of building trust, of building relationships, and, even pursuing, the education of the non-Indigenous public. I know that a lot of Indigenous people have been faced with so many stereotypes for so long.
Totally.
That, it takes so much effort to guard yourself from those stereotypes. But then because of this process of reconciliation, or because people are reading about the horrors, the true horrors of the residential school, all of a sudden, people may be more interested. They want to learn more, and they're expecting that you be providing them with all of this information. And I don't know necessarily that is a mantle that you have to take on. And I think it's a choice to do that, but it should never be a requirement.
Totally. Yeah. I'm learning that right now. And I think, sometimes you're put on a pedestal and you feel like a call to, but then you get burnt out. And I'm at this point in my life where it's like, I can talk about history. I love history. It provides us the foundation, but I also want to visualize a new future. And I think you touched on a really good point of, a lot of Indigenous people have troubles trusting these systems that are put in place by colonization. One of them being, the healthcare system. I have a hard time trusting just because of my history and also the history that's happened here to Indigenous people at the hands of the healthcare system and the racism and the stereotypes. And the other one is the child welfare system, the residential school being given a new name of the child welfare system here in Canada. And that being largely represented by Indigenous children. And then you look at the federal prison system and it's made up largely of Indigenous men. And so I think sometimes for me, it's hard to even trust like the law. And so I think on a basic level, what would your advice be for maybe an Indigenous person that comes interference with the law and, feels like their life is at risk? Like, what would your advice be?
So when we talk about life at risk, I mean, we're also coming from the perspective where children are our life, right? Mm-hmm. So I think defining the system of law that you're encountering is the first part. Is it a criminal system that you are becoming enmeshed in, or is it the child welfare system that you're becoming involved in? So which one of those systems would you like me to start with?
I will start with the prison system.
So the prison system, absolutely. I think I definitely agree with what you said about it becoming a new type of residential school. We see a lot of interconnectedness between, it's called a pipeline, right? Of young Indigenous children being first apprehended and brought into care, growing up in the child welfare system, and a direct line straight through to involvement in the criminal justice system, and then ultimately resulting in incarceration within the prison system. So as a parent of a child involved in the welfare system, I would give very different advice than the person who is at that point in their life where they have become involved in it from a young age and they're now in prison. And one of the scariest parts, I think, of prison is the fact it's in and of itself, it is a control mechanism. The prison system is all about making sure that you are kept away from the community you came from or the community that you are living in. And it basically tells individuals who have been sentenced, inmates, that you are somehow undeserving to continue living within that community. And so it is another means of making sure that we are segregated from support systems, from healing, from our community, our families, and then placed into institutions where the reality of the vast majority of federal institutions is that Indigenous people are screened not for minimal security. We are overwhelmingly screened for medium or maximum security, which means that there is less access to cultural programming. There is less access to elders, to anything that keeps us in touch with who we are as Indigenous people. We essentially become an inmate number. And that is the ultimate sense of state control, in my opinion.
Well, it's kind of like, weren't they given numbers too? Like, well, we're still given numbers with our status cards.
Oh, absolutely. Absolutely. The only difference is that to go to prison, you don't need to be Indian status.
Yeah, but I mean, so when we talk about these things, it's hard not to like feel hopeless in a way, because we see how corrupt the system is. And so are there ways, like, what's currently shifting, if anything, within these systems, and how do we give Indigenous people the right to even just like survive and to live and to not have to worry about all these barriers that are put up against us? Do you see systems starting to shift, or is there something that we can do as people to make the shift happen?
I think it's really interesting because what I see more and more happening is that um, non-Indigenous systems of control, like the child welfare system, like the criminal justice system, is being utilized by the state, giving a little bit of power or control over to First Nations communities. And I think we touched on this briefly in part one, is that by giving them just a little bit of power or control, and then framing it as an Indigenous entity or an Indigenous institution that still have all the same rules and are built on all of the same ideologies of power that the non-Indigenous institutions are. Are you really making the situation any better? And so
Mm,
something that comes to mind is the number of Indigenous child welfare organizations
mm-hmm,
there are across Canada. The number of policing, Indigenous
mm-hmm,
policing. And so I think it's important for me to say up front that while I'm not saying that there aren't aspects of our culture that these agencies contain that make them better
mm-hmm.
than if they didn't have those aspects, I do have to question as to whether or not putting this label of Indigenous in front of it, which to me signifies that it comes from inherent customs, traditions, where we didn't have, quite frankly, policing, what it looks like in the modern day.
Mm-hmm.
Our policing didn't have that. Um, we had, very different systems, related to specific roles and responsibilities of our clans, with specific duties, the peacekeeping function. Certainly not walking around with guns,
Mm-hmm.
weapons that can seriously harm you, and handcuffs.
Yeah.
Um,
Yeah. Yeah.
Very, very different systems. And yet somehow when you put this word Indigenous in front of policing, you're
It's
led to believe that this is something that our First Nations have created.
yeah.
And yeah, and
It's
so
not. It's like, it feels like cognitive dissonance in a way. I saw a Coast Salish painting on a cop car, and it just felt like very, I don't know, like very, yeah, like cognitive dissonance. Like the two didn't go together. Is that kind of what you're saying?
exactly, exactly. And I think that one of the concerns that I have is that it certainly lulls communities into
Mm-hmm.
complacency, where they think that, oh, okay, now that we have our own First Nations Child Welfare Society, or because we have our own First Nations policing, that
Right.
somehow this fight to take back what is truly ours and the right to exercise it under Section 35 is going to be lost. And that, I think, is almost what the state depends on. It's what it's relying on at the end of the day.
Yeah. Well, it feels like a lot of like performative activism and like there's a lot of talk and there's never really action. I feel like we've been talking about what Indigenous community needs for years with the Truth and Reconciliation report, with the calls to action. And so what type of law movement is needed to see justice for missing, murdered Indigenous women and girls in the Two-Spirit crisis and residential school survivors?
I think that if we are going to make any type of significant headway in addressing these problems, it needs to be with the fundamental recognition that there is a lot of healing in our communities that needs to be done. And that healing, as Indigenous people, we need to recognize is not going to happen from others. It's not going to come from anyone except for us. We need to heal, help each other heal in ways that only we can. Having said that, though, there are always going to be people who are predatory in, a very non-Indigenous setting, very much urban settings, very much people who, and we've seen this with non-Indigenous organizations that have come into reserve communities to offer programming and services. And then a lot of abuse has resulted from that. So it's recognizing that Indigenous people can't always isolate themselves from the rest of the world. There will be those instances in the future where there occurs harms and violence. And when that happens and we have victims, then they deserve to have all of the steps performed and all of the actions taken to ensure that the police are doing a proper job in the investigation of what has happened, that racism and discrimination stays out of the way that Indigenous people are treated within that system. We need to make sure that we're holding people, as you said, in the healthcare system accountable for when we go get help. Oftentimes as people who are victims of abuse and serious assaults, physically, sexually, we always think of how poorly they're treated by the criminal justice system and the police. And we forget sometimes how poorly they're treated by the very people who are supposed to heal us in the first instance physically, which are those hospitals, those doctors, those nurses, which tend to those immediate physical affects and how detrimental racism is within those environments.
I've witnessed it, well, from myself and also from my brothers. And so it really, I don't know. I didn't really have any faith in the police or also some of the healthcare systems out in Alberta. But I'm curious to know, there's a lot of talk around, defunding the police. Do you think this is possible, attainable? Do you think that we should defund the police? What are your thoughts around that?
Absolutely.
I'm like, are you allowed to talk about it?
No, a huge supporter. I would give that 5 out of 5 stars.
Sweet.
But having said that, I think if we're talking about defunding the police, we actually need to take a look at a breakdown of where does that funding go for police. And it's not going towards how to mitigate situations where the person is in mental health crisis. It's not going to situations where how do we de-escalate violence. It's not going to situations that are mostly built on community as this relationship building and relationships with the community. It's not going to, how do we make our police officers not racist? That's not where this funding is going to.
Yeah.
It's going to weaponry, arsenal. It's going to increased policing presence of people who are armed with all of the above. Like, that is where so much of that funding goes to. And so when we talk about defund the police, yes, let's stop equipping them with weapons that can kill, and let's start putting that funding back into some amazing initiatives, like teaming up with mental health nurses, teaming up with mental health organizations, really addressing the areas that we see the most harm when police interact with Indigenous people. Where does the most harms occur? And then putting the money towards that.
Yeah, well, you see it throughout history of there's been so many Indigenous people that have been harmed at the hands of the police, and a lot of them failed to get justice within the system. And so now we're finally able to hire lawyers, but I guess we talked a little bit about it at the beginning of knowing our rights as an individual, as an Indigenous person through Section 35, I believe you said it was. Is it Section 35? Yes. And so if someone were to come into contact with the police, we're given advice of like, just show them your drivers right away or show them your status card. Do you have any tangible actions that you would advise like an Indigenous person if they were to get into a situation with a police officer?
Yes. So there is a difference between our inherent rights that have been constitutionalized under Section 35, which is our treaty rights, our rights on the land, and then our rights to the land. But another part of that Constitution is the Charter, right? The Charter of Rights and Freedoms. And that is applicable to everybody. And that is, when it comes to policing, it's actually very interesting, because if you're stopped on the street and police approach you, yes, there are rules with respect to provision of identification. Obviously, my advice to clients is always, there is not a requirement to offer more information than necessary, but to keep and guard your safety, being, polite, being respectful. You have a right to ask for badge numbers. You have a right to ask for names. You have a right, there is a right to record.
Okay.
So if you are in a community and you see things going down that are going to lead to violence or have already gotten there. There is, we would not have some of the most horrific scenes of abuse that we've seen from police officers over the last year or two have come from bystanders who are left with a feeling of helplessness because of not being able to intervene, knowing that police officers have guns and can use force. But media is in and of itself a weapon. And so recording, making notes, making complaints, those are all things that we can do to ensure that not only your personal rights are protected, but the rights of your community members. And there is actually, there are beautiful, and I would hope that every province and every Indigenous legal rights center and every would have little cards, little wallet cards that you can, and I'm more than happy to send you an example of it. That goes over those initial encounters, and it's kind of like if this happens, this is what you should do. What is that? Choose your own adventure.
Yeah. Well,
if you really want to get into some trouble, ignore this.
These are your options.
But it does help though, because I find that it's in those situations where your adrenaline is running and there is, significant fear or anger towards police, having a quick go-to is very useful.
Mm-hmm.
And then obviously, knowing that you have the right to complain, that you have the right to, that every policing body across this country has an oversight agency, that, you know, even if I like to, you know, what I always like to say is that even if very little police complaints ever vindicate the person filing them, you know, unless you do have, you know, that kind of video evidence,
Right.
It becomes a he said, she said.
Right.
But regardless of that, even if you are ultimately not successful in that application, the fact that you make that police officer's life hell while that is being investigated, and the fact that they have to defend their actions to an oversight body, and the fact that they don't just get away with it and get to move on to the next day as though what happened to you doesn't matter, that is empowering in itself. And you can just imagine, for every negative encounter that our people experience, if every single one of them people complained, and there was a full complaint system that had to process that cop had to undergo, you know, it's putting that pressure on and making their life miserable because of their racism and because of their discrimination.
Yeah. I think it's so important. I think sometimes you feel helpless in those situations because of the power dynamic, and you feel really disempowered. But, you know, this one thing that I think empowers a lot of Indigenous people is the right to defend the land. And so there's this, we've all heard about it, the land back movement. I'm curious to know how you would define the land back movement, and do you think it is possible to see in our lifetime?
Oh, so this is concerning one of the files that I'm working on now. Aboriginal Legal Services is requesting leave to intervene in the 1492 Land Back Lane injunction case, where Six Nations of the Grand River community members, set up a camp on land that was going to be developed, knowing that this was part of the Haldeman Tract, which there has been land claims and in place for decades at this point. There are issues with respect to the superior courts in Canada giving injunctions and granting injunctions to private parties who want to develop or mine or explore the resources of lands that we've been entrusted with to take care of traditionally. And so when it comes to a situation like that, and you know that if an injunction is granted against the Indigenous land defenders, and they have set up camp, they have settled there, they're not letting that machinery in, they're not letting this settlement occur, and then injunction is granted. The consequence of not following through on the terms of that injunction and removing yourself from that space is that you will have charges, most likely criminal or civil contempt of court charges that will be brought down on you. And that is, there are so many issues with that. When you consider that, you know, the direction of the Supreme Court of Canada to the Crown, to the state, has been always negotiate with the purpose of reconciliation. Disputes, Section 35 disputes, which include the land title or rights on the land, need to be resolved. The best forum for their resolution is not in a courtroom. It's to come to an agreement. And, you know, the problem is the state doesn't, the land claims tribunal process has how many, hundreds of claims under it. The average length of time, I think, is 8 years for the smallest of claims. It is such a slow moving beast that ultimately what happens is that the very rights that Indigenous people are trying to protect are getting destroyed and extinguished.
Literally.
By injunctions that allow the private interest to come through before we are ever given an opportunity to actually have our day in court, if that's what it comes down to. And so there are just such serious consequences for Indigenous people, for Indigenous defenders. My challenge, if I'm permitted to make it in the court, my challenge will definitely be through every stage of that process, where before a superior court grants an injunction, which is supposed to be an extraordinary remedy, then what do you need to consider before making that order? And in my position, I don't think, if this is an assertion of Section 35 rights, if I was a superior court judge, there would certainly be declining of making that relief. I would, wait until trial. Mm-hmm. Because the problem is that once those third-party interests get in there, everything that we're trying to protect and trying to keep safe is going to be destroyed by the time the matter actually goes through court, right?
Mm-hmm. Well, and I think people fail to understand, like, this is our livelihood, and like everything that we're trying to protect is needed for humanity. This one follower asks, how can law be used to shift Crown land parks into Indigenous lands for stewardship? Like, if reserves are less than 2% land, how do we shift this to 50% of lands for the nations? But what I'm hearing is it's like there's a lot going on.
Yes, and I think it starts, with those treaties and the lands that were supposed to be set aside for Indigenous nations. There is the filing of a land claim and like I said to you, it's not a good system in terms of either haste or efficiency in terms of resolution of these claims. And so part of that issue is that if the Crown could get it together, and if they could develop a process whereby these were resolved and an agreement was reached, where perhaps for some of the land that was improperly settled on, jurisprudence case law has told us they're not going to force entire cities, right, of non-Indigenous people to vacate lands. But there will be compensation, right, that will be provided, in addition to land for other areas, right, that they may be also claiming. There is also a really interesting provision that has been integrated into a lot of treaties that have been decided post 1982 and are actually frequently used in places like New Zealand as well, is the right of first refusal. Where in the alternative for the land that has already been settled and there are already cities or towns or wherever, the money that is used to compensate for the fact that the Crown was in the wrong, that money can be utilized towards purchasing or having the option to purchase Crown land that is either available currently, or if in the future the First Nation, the Crown decides to sell land that previously it didn't want to, decides to sell it, then you'll be given the right of first refusal. So you can choose to either buy it or to not buy it. And so it's interesting in this way that we can fashion agreements. And this is why this process of negotiating and having our rights advocated for this is how we we go from having, 2% of land to taking control over how do we manage our compensation? What do we put the monies towards? In addition to, not the majority of land that we claim should be ours has not been settled. It's just Crown land and is used for natural resource extraction. And so in instances like that, absolutely, we should be advocating for that land to be returned to our stewardship. Absolutely. But then, for those places that we can't just be given back because they are settled, then they should be monetarily compensated. And we should have within our own governments systems where our community is able to decide and determine how we utilize that compensation to make sure that we can continue to add to our land, to our resources, to ensure our sustainability into the future.
Well, that was going to be my next question. I don't know if we touched on this the last time I talked to you, but Indigenous futurism, if you could imagine our future, what do you hope for when it comes to Indigenous futurism? How can you define it in your own words?
I think we did briefly touch on it, but in this specific arena of resolution of rights and land, I think this definitely touches on this idea that I have of this no more land claims with the government, where somehow we have come out on the other end and have made sure to protect and secure our rights through the process so that we don't have to do this all over again in future generations. So that, the decisions and the agreements that we reach with the Crown see us and our populations, our communities, being given the amount of resources we need to sustain ourselves, because the difference between Indigenous communities and what our traditional teachings and customs is that there's a balance, right, and a harmony that we live in, where this idea of constantly needing more land, that has led to, taking over of countries, exploitation of, natural resources, and it's capitalism in and of itself as being this ever hungry beast. Not having and adopting those specific ways of structuring ourselves, but instead moving to a futurism where we can have time and space to bring back, relearn our traditional ways for not just a few select people in our communities, but for that should be offered to every child in our community. And then to have the relationship with the land and the amount of land that we need and require and should by right have stewardship of, to be able to exercise those teachings and to be able to exercise that caretaking that we for our medicines, so that we have those spaces to gather the medicines, so that we have everything. The land has everything we need, but we need enough of it to be able to practice traditionally what we knew was going to keep us alive and to keep us healthy. That to me is where I see Indigenous futurism.
Well, it's literally like going back to the land. Like the land back movement can have so many meanings, and one is returning to source. It's returning back to Mother Earth and Father Sky, and I think that's where the true healing takes place, and that's the same place where like the revolution will take place. And you're doing so much amazing work, and I've learned so much from you. What has been, quickly, one of your highlights of your entire career, and then one of the challenges? I feel like you should start with the challenges, and then we'll end on the good note.
I think one of my biggest challenges has been to not be so frustrated with with what you see, as coming from sometimes the greatest legal minds, where you see decisions that have been written, or you see decisions that come out of courts, and you think to yourself, how can I possibly understand how you're so bright, or so you're supposed to be the most knowledgeable, like the carriers. I mean, a judge is supposed to be the carrier of non-Indigenous law. That's how we would understand that person to be. And yet to be so blind to everything that's going on around them. I think that is one of my greatest challenges. And also, why I do the work. So I guess that leads me nicely as a good segue into the final part of, why it is I think it's important to do this work, and for more people who are Indigenous to practice in these non-Indigenous arenas, because of the fact that it allows you, for those brief moments where you're before the court, to take off that blindfold that court is wearing, and for them to see through your submissions what the true reality is for Indigenous people, for our own systems, for our way of life, and how we see the world around us. And we have to remember that people who are Indigenous and are privileged enough to have grown up in those teachings, it's so foreign. Right? It's so foreign to what non-Indigenous people experience. And so the opportunity to be able to show the beauty of my culture, and to show the importance of it for the future of survival for all of us, is really where I feel like I'm making a contribution.
And then, like, in times where you are feeling like overwhelmed or lethargic or just like uninspired, what are the tools to allow you to reclaim your power and reclaim your own energetic sovereignty?
Definitely. I think that talking, for me, it's talking to those matriarchs in your society. If you want to find what seem to be just impenetrable depths of strength and resilience, it's truly in the women in our communities. And whether or not it's I need a shoulder to, shed some tears on, or whether or not I need, a good shake.
Good wake up.
It seems the grandmothers, the aunties, they know what you need at the time, and are more than happy to give it to you.
Totally.
So that's where I see my renewal of energy coming from, because those teachings are irreplaceable.
Well, that brings me to my last and final question of, what does the word matriarch mean to you, and who are matriarchs that you are currently inspired by?
Matriarch to me means that they are, for me, they're the knowers, and the strength. They embody the love, the discipline, the power, the vulnerability, and they carry it all so well. That to me is the beauty of matriarchs, and about the societies that we live in, that are headed by these people who make the plus, the minus, each side, each end of the spectrum. They embody all of it, and they make sure that it's inclusive. It's an inclusive space where you are understood, because it's all known, right? And they that's the wisdom, I think, that carries us forward.
We're in the era of like matriarchs rising everywhere. I'm continuously inspired by so many women in our nations throughout Turtle Island that are doing incredible work and continue to do the work in a system that has sought to suppress our voice. And so I really admire you and all the work that you're doing. And I know even one of your colleagues, I believe, she's like, I'm so excited for this episode. That's my boss. So I'm sure you're a matriarch in a lot of people's eyes. Thank you so much. Hi, Caitlyn, for sharing your time, your wisdom, your energy. I'll put a few of the resources in the link below. And yeah, thank you so much.
Miigwech for having me.
I hope you enjoyed today's episode, and I would love your feedback. Follow me on Instagram at ShaylaJOH, at matriarch.movement. And don't forget to subscribe on the pod platform of your choice and review and rate where possible. I'll be back in a week. Hi. Thank you so much for tuning in.
Thank you so much for listening to a podcast by The Brand is Female. I'm Ava Hartling, and this episode was produced by our team. Sound engineering by Isabel Morris. Research and production support, Claire Miglionico. Marketing and digital growth, Kayla Gillis. And partnerships, Natalie Hope.